American democracy stands for fairness.
I don't think it's fair.
Fairness without regard to race, religion, gender, language, national origin, or handicap.
I don't think it's fair, no. I don't think they're fair at all.
Fairness. The principle is a matter for practice.
It's not fair because, you know, there's the minority, like black man or black woman. It depends on what color they are.
What do we have coming up next?
We have the settlement conference.
Oh, that's right.
Counsel in Webb versus Network Services Incorporated.
Last case that we have today.
Yes, I believe it is.
No, sir. I said lawyers only, no parties.
Judge, I am the lawyer for Network Services.
Hey, Bob. Good to see you.
Hi, Jim.
Hey, I hope your case is better than your golf game. Yeah, look, let me take that for you, honey.
I can handle it, thank you.
Prejudice in the courtroom or anywhere else isn't new, but what does it have to do with justice? The question is whether an on or off-the-record gesture or offhand remark affects the outcome of court actions or confidence in the court system. The Michigan Supreme Court task forces on gender and racial ethnic issues in the courts say yes. Prejudicial behavior, whether overt or, as we shall hear, invisible, is a very real hindrance to fair play. We find that bias seldom wears a white sheet in today's justice system. More often, bias against women and minorities is subtle. Such is an assumption that minorities are clients, not lawyers.
Judge, I am the lawyer for Network Services.
Implying favoritism to the good old boys.
Hey, Bob. Good to see you.
And condescending to women attorneys, commenting on their dress or expressing familiarity.
Here, let me take that for you, honey.
In 1986, under the leadership of Chief Justice G. Menon Williams, the Michigan justice system heard the admonition, "Physician, heal thyself," and began an examination of the entire justice system. The Citizens Commission reported that women and minorities didn't trust the system. They believed that it was biased against them. In 1989, Chief Justice Dorothy Riley convened two task forces, one on race and ethnic bias and another on gender bias in the courts. Testimony from Detroit to Marquette from lawyers, court personnel, and judges concluded, among other things, that only white males, whether lawyers or judges, fail to see bias. That bias is real and runs deep, from lawyers to court personnel. That bias is dangerous and affects the outcome of cases. That bias is powerful. It impacts on the respect that allows the justice system to function fairly. Former State Bar of Michigan President Robert Webster talks about the task force process and two very different worlds, one where bias obviously exists and one where it is invisible.
Both task forces found and verified that most assuredly within the court system, within the profession itself, there was discrimination as such, invidious discrimination, lack of sensitivity, stereotypical thinking that related not only to interhuman relationships, but also related to, for example, prosecutorial attitudes in domestic relations areas, in bonding in criminal cases. They found sexual harassment clearly still existed. Sometimes it existed just by insensitivity, sometimes just by direct overt acts. that there were failure of equal employment practices within the judicial area and in state agencies that were related to the judiciary, that there were problems in the private employment sector in law firms. There were difficulties on the gender side in progression within law firms related directly to gender issues, and that there was a propensity because of the structure of the profession for minorities to not have full access to law firms, and as a result they were involved more in solo practice. All that kind of thing were findings of the task force.
The ways in which the court addresses a lawyer does impact on how that lawyer is treated by other lawyers and courtroom personnel. Forms of address ultimately affect the lawyer's real mission to serve the client.
I've seen myself on one occasion addressed as honey, and on many occasions addressed by my first name when opposing counsel was addressed either as Mr. or counselor. And I think that the important part of that is that it denigrates your position. It makes you feel somehow that you're not quite as important as your male counterpart. When it happens to clients and the judge calls the client Sally instead of Mrs. Smith, it diminishes the client's perception of themselves as well.
Have a seat, gentlemen. Yes? Yes. All right, I'll take care of it. I'm going to leave you to have some preliminary discussion between yourselves on these discovery problems. I have a little domestic relations matter to knock out.
Now look, this case isn't really worth much. Considering everything, it should be settled for nuisance. I mean, the mediators almost laughed at this claim.
Probably all we need in this case are a couple of pictures of the plaintiff's spandex tube top, and she's out of court.
Look, counsel, sexual harassment is a real claim. What you have going for you is a mediation from an all-male panel, a golf buddy judge, and your own attitudes. What I've got are independent witnesses, a plaintiff with a solid work record, and the law. Now, let's get to those discovery problems.
Certain kinds of cases, like domestic relations and domestic violence, are often not considered real cases. Parties in domestic cases, particularly women, have expressed frustration and anger at not being taken as seriously as, for example, the corporation in a $1 million lawsuit. Certain litigants also feel that their claims are disregarded or discounted by mediators because of race, ethnicity, or gender.
It has been conclusively established that white people generally do not believe that black people are worth as much as they are. That is, that if you have identical cases, one with a black child who was run over by a car and one with a white child who was run over by a car with the same injuries, you will have differing verdicts, differing settlement recommendations, and it will be a larger amount for the white child than for the black child. Now, that being the case, and we all know that's the case, one would think that you would want the mediation panel to represent a wide spectrum of views, and you would want women and you would want people of color on that mediation panel so that there could be at least some give and take around what a particular case is worth, and then the attorneys who have to consider whether to accept that mediation evaluation or not will have something that's realistic. Because when you get to the courthouse, the jury is going to be made up of differing views. Different people, different backgrounds. Some people of color, some people not of color. And to have that process as it is, as fully integrated as it seems to be now, and the mediation panels as still as segregated, if you will, does not give you the realistic view of realistic proposals of settlement that you need in the mediation process.
Mediation panels that were surveyed were overwhelmingly white and male.
I think it's happening some of the time because the people who are in charge of doing one thing or another to include the names of certain people on the list, who don't view you as someone who is like them and therefore ought to be sitting there with them, simply make it difficult for you. They will find 8 million reasons why it was not on purpose and they didn't mean it and all kinds of things, but it's clear racism. I understand that white women, have the same kinds of problems, and there are probably the same kinds of reasons. Then there's a whole lot of just unintentional neglect. It is not that important to the white male power structure to have women and minorities in mediation, and if it were, then they would be there because there are certainly enough of us in the profession.
Do lawyers know, rely on, and play on these built-in prejudices as they plan their cases?
We found that 9 out of 10 people believed that politics at times influences judicial decisions. 76% believed that the poor were not treated as well as the affluent in courts. And more than a third believed that women were not treated as well as men and that blacks were not treated as well as whites. The commission, I think, was impressed by those findings, but they were more than impressed. They were moved by the personal testimony that they heard from people recounting experiences in courts and their own perceptions of disparate treatment.
Attorneys testified in public hearings that obstacles continue to exist throughout the entire legal profession.
I don't think there's any question that there is a ceiling, or there has been a ceiling in the past. This is one of those things that, as an African American, I could have told you based on my perception as to whether such things existed without having a task force report. But it was necessary to document these things. And for the same reason, I say I don't think there's any question in my mind that the glass ceiling has existed in the past and to some extent is still there now. But how do you make it go away? And this may sound like a pessimistic viewpoint, I don't think that it will go away in my generation.
The Good Old Boys Network is very strong, and the role it plays, I think, is not so much in eliminating minorities and women, but in including white men.
I believe that gender bias is on a continuum from extremely overt actions to extremely subtle actions. For example, overt actions would be where a partner in a law firm says, we will never allow this woman, we will never hire a woman. Or if we hire a woman, we will never allow her to do litigation work. She will always be in the library doing research or writing wills. Or we're going to give this associate, this male associate, a larger bonus than this female associate, because he has a wife at home and 3 children, and so he has a family to support. And although she may have a family to support, her income is not nearly as critical to the support of her family as a man's is.
Contacts within their own community, maybe it's the church, maybe it's the neighborhood, that provide some portable clients, or the prospects of portable clients, is an advantage against someone who grew up in a poor area where there may not be any business owners of substantial worth in terms of private billings. That would be an obstacle as well.
Women that I have talked to have said that they reach a certain point and it then becomes difficult for them to advance. For example, partnerships are elusive, mainly because the requirements for partnership are so many billable hours that it's almost impossible for a woman to have a family and still meet that criteria. 2,600 billable hours a year, for example. That's a lot of hours per week if you also have family responsibilities. The problem seems to be that there's more flexibility for the men because they don't have those responsibilities at home.
While no person of goodwill denies that it's important to root out bias in the court system, it won't be easy. An important step has been taken, however, and that's to acknowledge that bias in the courts is not only morally wrong, but ethically improper. In September 1990, the Representative Assembly took that historic step. After vigorous debate, the Assembly approved an ethical standard prohibiting lawyers and judges from participating in invidious discrimination. There are other signs of improvement. The prestigious Institute for Continuing Legal Education, made aware of the painful lack of diversity in its faculty, aggressively sought women and minority faculty members. In 1990, the Institute increased women and minority faculty by a significant percentage. Another example, the Detroit Bar, in response to findings and recommendations of both task forces, established a committee on diversity.
The Committee on Women and Minority Involvement of the Detroit Bar Association was formed because I wanted to make sure that the Detroit Bar Association, although I was confident that it was at the time, fully complied with the recommendations of the task force, and that the Detroit Bar Association was fully representative of all aspects of our membership. And by aspects, I mean women, minorities, and everybody else who was a member of the bar, to make sure that our association complied with the requirements set forth by the task force.
I think that the commitment that the State Bar of Michigan has expressed by creating a special commissioner committee to deal with the task force reports and their recommendations is very important to the overall ability of people within the profession to make a change and to respond to the recommendations. Certainly the action of the Detroit Bar Association to create a committee and to establish as a goal the complete involvement of women and minorities within their association is another example of that. What we're talking about really is a cultural change, and to transform the culture of the legal profession, we'll need to have everyone participating. Certainly the people who are already in leadership positions, as well as those of us who aspire to them. It cannot be denied, I believe, that there still does exist a glass ceiling for women and minorities within the profession. It's a matter of access, the opportunity to have the top job assignments, the litigation experience, the promotions.
The demographics of American society are changing completely, and whereas it was true at one time that sometimes law firms correctly or incorrectly felt that their clients would not relate well to having minority or women represent them, that is not any longer so. As a matter of fact, the census figures show that by the into the 21st century, that minorities and women will outnumber men in the population in this country. As a matter of fact, in California, before the year 2000, the minorities will be in the majority, and in the majority, and by minorities I mean African Americans, Hispanics, and Asians, before the end of this decade will outnumber Caucasians in California. So this means that common sense and good business practice demonstrates that law firms should or are going to have to start looking at this in a different light.
As we move into the 21st century, eliminating all forms of bias is a vital task for us all. What needs to be done?
The recommendations could be grouped in educational activities, recommendations for Bar Association educational activities, and the Michigan Judicial Institute to incorporate programs to raise the level of sensitivity, to try to avoid stereotypical thinking, and techniques for achieving equality in all of the areas of the profession.
I think that the chances for fairness in the system must be correlated to the chances for fairness in the questions that are asked by the attorneys, the perceptions of the jurors, and the perception of the judge. The fairness for someone, let's say, of minority status will increase when there are people within the jury that can feel as if they can understand that person's position regardless of their color. When the attorney will not make comments that are intentionally attempting to dig at the biases of the jury, and when the judge itself, the judge, he or she, is able to make decisions that have no correlation to the color.
The task forces also recommended regulation, imposing ethical standards to prohibit invidious discrimination and impose responsibility to report such behavior in others. The task forces urged the profession to create standard objective criteria for assignments as counsel, guardians ad litem, as well as arbitrators and mediators.
I think the only way to resolve this is to have the court say, you will do it. How many mediators do you have? How many are women? How many are minorities, people of color? Do you have any Asians? Do you have any Hispanics? Do you have any African Americans? How many? All right, by this date you'll have this many. And I think that's the only way to resolve this, because they're not going to do it without being forced to do it.
The 21st Century Commission echoed the task force recommendations, urging that the entire justice system be monitored for bias.
I recommended to the Board of Commissioners that we create a new position, a new Assistant Executive Director position, which was ultimately called Assistant Executive Director for an Open Profession. Deborah Gaskin, who holds that position now, has been on the State Bar staff for about a year. The recommendation for that position was an outgrowth of efforts in this area that the State Bar has been engaged in for many, many years, starting through the creation and work of a committee known as the Committee on Underrepresented Groups in the Law, which at first concentrated on the lack of minorities and women in the profession. But the work of that committee quickly demonstrated that the problems were more than that, and that was emphasized by the two Supreme Court task forces on bias in the courts, on one of which I served, which made about 170 very different, varied recommendations that work was needed on this subject in the profession and in the courts, in bar associations, in law firms. And so it became apparent that this could not be adequately addressed by simply being one of 55 state bar committees, which got some staff support and did some work, but that it really required that we bring somebody on board who would concentrate in this area. And the responsibilities of that position are to address the problems identified by the task forces, to sensitize the profession, the judiciary, law firms, local bar associations to the problems that are encountered within the profession by minorities and women, and to raise their consciousness and to recommend ways in which they can address those problems and alleviate them.
Our society is heterogeneous in a way today that it never has been before. And the firms are recognizing, those who exist in the firms are recognizing that if they don't reflect the composition of society, they're going to lose.
Hopefully, by recognizing the flaws in the justice system, we can resolve those problems. And one of the things that we can do is perhaps lead society to a more open-minded attitude toward women and minorities, not just as they participate in the justice system, but as they participate in society.
So anyway, thank you very much.
Yes, and we'll be talking again,
We
I'm
sure
sure.
will,
Right.
yeah.
I'll give you a call.
Great.
Okay.
Okay, thank you.
Nice meeting you then.
And
Take
here's
care.
your client.
All right. How you doing?
Hey, this case ought to be easy. You have a girl and a...
Now hold it. Now we can win it, but we have two good lawyers and a case that, well, it's not as cut and dried as you think it is.
Times keep changing and progress goes a step at a time. For the court system, the right time to be fair is every time, because fairness is what the court stands for, isn't it?
I think minority males are treated real bad.
I believe there's a problem with that, the minorities. As far as the legal system, it is.
I still think there is some gender and race discrimination just inherently built in.
minorities, I would say no, it's not fair.